Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. आज के इस वीडियो में मैं आप लोगों के साथ लैंडमार्क जजमेंट्स डिस्कस करने वाली हूँ ऑफ द 15 डेज फ्रॉम द मंथ ऑफ जुलाई, दैट इज 1st of July to 15th of July. अगर आपने अभी तक ये सीरीज़ की कोई भी वीडियो नहीं देखी है देन आई वुड सजेस्ट दैट आप लीगल बी के प्लेलिस्ट पे जाके सारे वीडियोस चेकआउट कर लें. दिस इज अ जजमेंट सीरीज दैट वी हैव स्टार्टेड फ्रॉम द मंथ ऑफ January 2023. If you're preparing for any competitive examinations like judiciary, or if you are preparing yourself for your cases in the courts of law every day, you should be well versed with the ratios that have been passed recently in various judgments that are landmark in nature by the Honorable Supreme Court of India and also the Honorable High Courts in the country. I also try to pick up the most important ratios of these cases in these judgments. So you can definitely download these PPTs also with you, as it will be of great help that you will have a ready reference to all the cases with you. And अगर आपने अभी तक LegalBee को सब्सक्राइब नहीं किया है, go and subscribe it as soon as possible. If you have any queries, you can write to us in the comment section of this video or email us at hello@exambee.com. Call on 9205524028. So let us start with the landmark judgments in the month of July, that is 15 days, 1st to 15th of July. Every 15 days we are coming up with the compilation of these judgments. The first one is Teesta Atul Setalvad versus State of Gujarat. That the judgment has been passed on 1st of July itself by the Supreme Court of India. This is actually a SLP, special leave petition, आपको पता होगा, filed under Article 136 of the Indian Constitution. The SLP got admitted. SLPs जल्दी admit होती नहीं है, but अगर admit हो जाती है ये भी अपने आप में एक बड़ी बात होती है for the advocates, because that is also a question that has to be satisfied, that whether there is any substantial thing, whether there are any special circumstances that the court needs to admit it. So this was against the judgment of High Court of Gujarat, which has rejected criminal miscellaneous application for bail basically. So bail से related application reject किया गया था, and case was about fabrication of documents which was done during the Gujarat riots of 2002. Everybody knows about these riots, and the allegations were also including the then Chief Minister of Gujarat, currently our Prime Minister Narendra Modi ji. So it was relating to the Gujarat violence. So at that time a lady, she was an activist, and there were charges against her that she had fabricated documents. So she was in jail, and the Supreme Court has done what in this particular case? Supreme Court has come up with this theory of favored treatment. If there is a normal offense and section 437, if we are considering a bail application under it, then to a lady favored treatment can be made out, and the Supreme Court has held it without going into the merits of the matter, has granted her interim relief basically. The lady has got interim bail till the matter actually gets decided and the merits are actually found out. Till that time interim bail has been granted by the Supreme Court of India. Indira Devi versus Veena Gupta and others. In this case, the appellant has challenged the order of High Court of Judicature at Patna, and which is an order against the second appeal. So the question that was consideration was relating to a sale deed basically, that whether a vendor कौन होता है? Seller के लिए दूसरा नाम vendor होता है. So whether a vendor, that is a seller, can assign the rights that are contained in a sale deed, and if those rights are actually personal in nature, so whether that can be assigned. So the Supreme Court has dismissed this appeal and has upheld the decision of High Court that was challenged, High Court of Patna. What was held is important here, that if the facts of the case in hand are considered, we do not find that there is any term in the conditional sale deed which debars its assignment to any other person. The clause only mentions regarding right of repurchase. So that particular stance of right of repurchase that was assignable, this was held by the Supreme Court of India. So this is also a good question of civil law that has been discussed here. State of UP versus Sonu Kushwaha. In this case, the Honorable Supreme Court has dealt with a question relating to the guilt of an offender who is charged for sections 6, section 4, section 5 under the POCSO Act. And what has happened? The High Court has actually taken a lenient view. The Allahabad High Court has taken into consideration that the guilt of the accused is only under section 4 and he should be charged only under section 4 of the POCSO Act. But then again in the appeal, when the respondents came to the Supreme Court, they came as appellants. Supreme Court has observed that the POCSO Act was enacted to provide more stringent punishments basically. So the offense of child abuse, these needs to be stopped. So taking a lenient view over here is not something which is permissible. So court has rejected the Allahabad High Court's judgment and has actually again restored the judgment of the trial court and has said that section 4, 6, 8 and 10 of the POCSO Act, these are for various categories of sexual assaults on the children. Section 6, if you give it a plain reading, it does not leave any kind of discretion to the court, and there is no option to impose the minimum sentence that has been done by the trial court. So the trial court was correct in this view. So this was the thing that was discussed. इस judgment को आप detail में भी पढ़ सकते हैं, इस वीडियो को pause करके भी आप इसको अच्छे से पढ़ सकते हैं, या PPT को simply download कर सकते हैं. Court has considered the provisions and the interpretation of the provisions of the POCSO Act over here. Ravi Khandelwal versus Taluka Stores, another judgment by the Supreme Court of India. In this case, basically, the respondent was a tenant and tenant landlord dispute है, ऐसा समझ लीजिए. So यहाँ पे अपीलेंट ने क्या किया था, अपीलेंट ने परचेज की थी प्रॉपर्टी जब ऑलरेडी वो टेनेंट उस प्रीमाइसेस में रहता था, एंड अपीलेंट हैज फाइल्ड अ सूट फॉर इविक्शन, एंड देन दिस मैटर went under the section 14(3) of Rajasthan Premises Control of Rent and Eviction Act. And what that prescribed, that filing of suit for eviction within 5 years on the date on which the premises was let out to the tenant. So that is not allowed. There was a bar earlier basically, अब वो bar actually नहीं है, वो भी हटा दिया गया है. But ये case तो पहले file हुआ था and cause of action भी पहले का है. So the appellant succeeded in the first appeal also. The district Court of Jaipur actually agreed that the respondent's claim that premises had been leased to him, that is the tenant said that it was leased to him, but वो lease prove नहीं की गई थी basically. So फिर हाई कोर्ट ने क्या किया, यही चेक किया कि सेक्शन 14 क्लॉज 3 जो है राजस्थान प्रीमाइसेस कंट्रोल ऑफ रेंट एंड इविक्शन एक्ट का, उससे रिलेटेड रिस्पोंडेंट को सेकेंड अपील में क्या रिलीफ मिल सकता है. एंड देन सुप्रीम कोर्ट के पास मैटर है, एंड सुप्रीम कोर्ट हैज डन अ लिटरल इंटरप्रिटेशन ऑफ दिस पर्टिकुलर has said that literal interpretation of section 14(3) of the act will actually lead to absurdity. हम लोग literally नहीं जा सकते, and अब तो ये provision actually बार भी हो चुका है. This also the Supreme Court has considered in this particular case, has not taken a narrow view like the High Court and has ruled in favor of the appellant and rejected the order of the High Court. So what the Supreme Court has observed, that for the protection of tenant this provision has been, so इस case में tenant के actually interests affect हो रहे थे, so the court has actually not gone for the literal interpretation. This we have to remember over here, and has said that the objective is that from the date a tenant acquires a right, he must have right to continue in the premises for a period of 5 years. So this is subjected to fulfillment of terms and conditions of the lease. So lease को consider किया है सुप्रीम कोर्ट ने यहाँ पे, जो हाई कोर्ट ने actually consider नहीं किया था, because the lease was not proved. This was the thing that was discussed in this particular case. So Matthew Alexander versus Muhammad Shafi, and another case that has been decided by the Supreme Court of India. In this case, the appellant is aggrieved by the quashing of opinion that was formed on the final report. You all know कि FIR रजिस्टर होने के बाद चार्जशीट फाइल होती है. इस केस में सप्लीमेंट्री चार्जशीट भी फाइल हुई थी. This is a case relating to accident, and again the established guilt and negligence related questions have been discussed over here. So in the opinion, what had come, that the persons who have died basically, who were the appellants, means appellant's son and his friends were driving a car and they met with an accident by dashing with a lorry that was a gas tanker basically. So यहाँ पे जो guilt है establish हुआ था गैस टैंकर लॉरी का, and then later on it was found by the High Court applying the principle of res ipsa loquitur that the negligence was there on the part of the deceased as well, the victims. So the question again came to the Supreme Court of India, and the Supreme Court said that in the impugned order of High Court, this has to be actually set aside, because just adopting an approach like this is not proper, that there was res ipsa loquitur and the negligence was there on the victim's side as well. Court held that culpable rashness, if is there under section 304A of IPC, then that will be considered more drastic by simply rather than simply imposing negligent liability under टॉर्ट्स. टॉर्शियस लाइबिलिटी आप अप्लाई करके इस केस को नहीं छोड़ सकते, इसका सीधा सीधा मतलब ये है. एंड अगर नेग्लिजेंट रैशनेस यहाँ पे देखी जाती है, सो इट विल अमाउंट टू बी अ केस अंडर सेक्शन 279 एंड डेफिनेटली 304A of IPC. The claimants actually applied for compensation also. So of course for compensation related we have to consider preponderance of probabilities, and beyond reasonable doubt it need not be proved for giving compensation under the motor accidents claim tribunal, by the motor accident claim tribunal. Are you understanding? I hope कि इस केस में बेसिकली मुद्दा क्या है, compensation का. विक्टिम की फैमिली को compensation मिलना चाहिए. The appellant should get it, and by the motor accident claim tribunal, when the case has to be decided, they have to consider the case on the preponderance of probabilities and not beyond reasonable doubt. यहाँ पे tort और 304A के elements ingredients को भी compare किया गया है. So this is also an interesting case. Now let us see some judgments of the Bombay High Court. Khanna Rayon Industries Private Limited versus Swastik Associates and others. Basically this is a case relating to amendment of pleadings, but इसमें सीधा सीधा commercial court से related बात की गई है. Commercial court के पास plaint file हुई है, and अगर अपने judgments अगर आपने plaint file करते वक्त important documents mention नहीं किए हैं, later on you come up with those documents, and it was reasonably it was expected that the documents were in your possession, then that is something which should not be permitted under order 6, under order 11 rule 15 of CPC. This is specifically for the commercial courts. So Supreme Court has observed in this present case that the application for amendment that has been filed on behalf of applicant, this is an application that has to be placed on record. Additional documents are there. तो additional documents जो यहाँ पे place किए जा रहे हैं, that is not a simple amendment. That is something which is substantial, which is proposed, which was not proposed earlier. So actually the court has rejected that particular amendment application. इसमें दो amendments थे, एक amendment grant किया गया है, but जो दूसरा amendment है, that was rejected by the Supreme Court because the plaintiff has to reasonably prove that why these substantial judgments, substantial documents were not placed on record earlier along with the plaintiff. As per the order 11 rule 15 of CPC, this is the basic provision for the commercial courts, and order 6 rule 17 आपको पता ही है, that is for amendment of pleadings. Tondiram Bhikaji Sonavne versus State of Maharashtra and others, another case by the Bombay High Court that is relating to simply the project affected persons. This is a specific act, specifically there is an act, Maharashtra Project Affected Persons. Under section 2 clause 10, the person who is the petitioner, he was covered, but his prayer was rejected basically, and he was not covered by the government and some of the officials, so they have been made respondents over here, and the court has considered that he is covered under the project affected persons. And also if Supreme Court has held that if a GR or a circular comes later by the government, then that GR or circular will not have an overriding effect on the provisions of the act. Even if that GR or circular has come, you have to cover this person as per the section 210 of Maharashtra Project Affected Persons Rehabilitation Act, and he should get a certificate of PAP under that act. इससे कोई फ़र्क नहीं पड़ता कि बाद में कोई GR या सर्कुलर आया है, अगर वो इस प्रोविजंस में फिट बैठता है तो वो GR या सर्कुलर की वजह से उसके राइट्स अफेक्ट नहीं होंगे, एंड दैट विल नॉट हैव एन ओवरराइडिंग इफेक्ट. यू कैन रीड द फैक्ट्स ऑफ दिस केस ऑल्सो इन डिटेल. Now one more judgment we'll take up for today's consideration from the Kerala High Court. That is relating to illegal detention. Basically means detention order है, ठीक है. Kerala High Court has held that a person has been detained under section 3 of Kerala Anti-Social Activities Prevention Act 2007. But then if there is an unreasonable delay on the part of authorities, if they are seeking some additional particulars and they are not able to fetch that, whatever reason is, that unreasonable delay cannot be continued, and the court has actually, it was a division bench of the Kerala High Court, has taken into consideration the factual circumstances and has quashed the order of detention and has ordered the release of the petitioner from the detention, because the detention, preventive detention is okay, you can do, but in that case if it is getting delayed unreasonably, the documents or whatever reason is there, so the court has immediately ordered the release of the petitioner in this particular case. So this was the variety of judgments that we had to take up for consideration, and I hope this video is definitely going to help you out. अगर आपको कोई भी point समझ में नहीं आया है या कोई queries हैं, you can directly reach out to us in the comment section of this video. And yes, don't forget to subscribe to LegalBee. Thank you everybody. Have a good day.